My name is Frank Ally. I'm a California attorney primarily focusing on family law issues. Now let's get started. Welcome to part 2 of our episodes on community and separate property in California. The Marriage of Haynes says, a basic rule of community property system is that all property acquired during a marriage is community property. Now, the best way I think to figure out what community property is to understand what separate property is. So in California, separate property is specifically defined in California Family Code 760. And there's really 3 parts of separate property. Number 1 is property that you owned prior to marriage. Part 2 is property that was acquired during the marriage by gift, bequest, or devise. That would be somebody gives it to you, somebody wills it to you, or somebody through a trust transfers property to you. Okay, so 1 is property that existed prior to marriage. Part 2 is gift, bequest, or devise. Or the third part is property that is rents, profits arising out of other separate property. That belongs to you as well. Those are separate property. So it's important to understand that anything you acquire during the marriage, with those exceptions that I just gave you, would be considered your community property, which means it belongs to both of you, not individuals. So Fred's income is no longer Fred's income, Wilma's income is no longer Wilma's income. That's what we discussed in the first video. There is a rebuttable presumption that anything acquired during the marriage is community property. So if you're going to claim something that's acquired during the marriage is not community property, that it's separate property, such as the rents issues and profits issue, you have the burden of proof by a preponderance of evidence to prove that to the court. Let's talk about a couple specific examples. The 401k that Fred owns prior to marriage, and he contributes during the marriage to that 401k. What's happened now is that community interest in that 401k doesn't go away because it's put into Fred's pre-existing separate property 401k. What's happening is he's converted his 401k to both part separate property and part community property. We're going to talk about that in another video about tracing and the Walrath assumptions that are going on. But for now, just understand that you can have an asset that is part community and part separate property. But again, if you commingle things, the burden of proof is on you to prove the separate property aspect of it. If somebody owns a business, so somebody runs a business making widgets, and they go to the factory every day and they earn an income from this widget manufacturing. That income earned, even though you're self-employed, is community income because you're applying community efforts during the marriage to acquire income, and that income would be separate property. However, the profits from that widget operation would not be considered community property. This gets a little complicated. It usually requires the inclusion of accountants or forensic people involved to split things up, but it's pretty simple, basic math that we're doing here. Somebody owns a business. We figure out what is the value of the person's labor in the business. They get paid for that labor. They get paid for the time that they spend at the business. And that money they earn is community income. Any money left over after you're paid for your community efforts would be the profits of the company. And if that company is separate property, then those profits would also be separate property. If you own a house prior to marriage, that's your separate property. But what if you own a house that has a mortgage on it? And you go to work, your regular job, you work for the state of California, you take your paycheck, you come home, you put your money into a joint account or even a separate property account, because it doesn't matter what kind of account you put it in. Community efforts are community efforts and turns your income into community property. but you use that community income and you pay your mortgage with it. Well, suddenly we're paying for your separate property with community income. That creates a community interest in your separate property. Now, on the community interest in a house, we're going to talk about that. We have a separate video on something called Moore's-Marsden calculations. And that's how you tell how you allocate separate and community interest in a pre-owned property. We're going to have another series of episodes on Pereira and Van Camp presumptions with regard to businesses, because community efforts that grow a business during the marriage could result in a community developing an interest in a previously separate owned property. And again, what you need to remember here is that this is all governed by presumptions. If you're going to mix property together and you're going to acquire equity in the house by paying down a mortgage or growth in a business, you now have the burden to prove what your separate property is. And if you can't prove your burden, that entire asset could be considered to be a community asset. We got more to go, but for now, I'm Frank Ally. I'm your ally in family law. Hope you enjoyed this, and I'll see you in the next episode.